It's time to focus on seniors with Helping Seniors TV. The television show designed to make you aware of senior issues and needs, as well as to acquaint you with the resources available to help you age in place and with dignity. Now, here's your host, Joe Steckler.
I'm Joe Steckler, and welcome to Focus on Seniors, the television arm of Helping Seniors of Brevard County. Our show is designed to provide you with information on how to develop your own aging and care plans. My topic today is guardianship. And here with me is William Johnson, board certified OLA attorney of William A. Johnson, PA. Welcome, Bill.
Welcome, Joe.
It's always a pleasure to have you on the show. We've done a lot of these shows over the years, but when I sent you an email the other day about what we wanted to talk about for this show, you said guardianship was a hot topic.
Yes, it is. It's a very hot topic, and if you look at what our legislature is looking at this year, they may be doing some work on guardianship over the summer, looking at various ways of improving our guardianship statute.
What, without having the law, passed or anything like that, what excites you? Well, as an attorney, is this something for the good or for the bad? What is it? Well,
what's happening is we're having a lot more guardianships. The demographic wave is hitting, and that we're ending up with a lot more seniors, and a lot more seniors who are over 80 years old. And subsequently, a lot of those people live with acute illnesses like Alzheimer's disease, various forms of dementia, stroke, Parkinson's, things that require guardianship and put somebody in place to handle their affairs.
I'm sure that most of our viewers, maybe I'll use the word many, have heard the term guardianship. But I would expect that most people, when they hear the word guardianship, they conjure up all kinds of things. What is a guardianship?
Well, guardianship is used in the statutes a lot of different places. We talk about guardianships where we deal with incapacitated individuals. We talk about guardian advocates where we're dealing with somebody with developmental disabilities. We talk about guardianships for minor children, natural guardians, guardian advocates with Baker Acts. So it's used a lot of different places. What we're really talking about today is what you would call your guardianship for an incapacitated person. And that is where you go to court, have somebody declared legally incapacitated, and then their rights are taken and delegated to someone who is called a guardian. And you have a guardian of the person, a guardian of the property, and the rights of the person go to the guardian of the person. The rights dealing with the property go to the guardian of the property.
Is this a guardianship, the type of guardianship that people enter into willingly, or is this
Well, you can have a voluntary guardianship. If a doctor certifies that you have capacity, you could actually do a voluntary guardianship and have a guardian appointed to make your health care and financial decisions on your own behalf. You could also revoke that, obviously, because you have capacity. Mainly the ones we're dealing with are the ones where the person has lost capacity and we have to go to court to have them adjudicated incapacitated. And the way we do that is we file a petition for incapacity with the court system. The court will appoint a 3-member examining committee, a doctor, and 2 other medical professionals. They will go out, examine the person, report back to the court whether they think the person's partially, totally, or not at all incapacitated. And then the court will also appoint an attorney to represent that individual. And if the examining committee comes back and says they're partially or totally incapacitated, then we move on to the next step, which is usually the appointment of a guardian.
You mentioned 3 people. And who was the first person you said?
It has to be a doctor currently.
A doctor. And then you mentioned 2 other people. But years ago, when I was the director of the Alzheimer's program, I was asked many times to be one of the 3 members of the board that interviewed the person.
Correct.
Do they still use people like?
Well, they use social workers, nurses, people who have expertise in that kind of diagnoses, because usually what we're looking at is some sort of psychological incapacity. Not all the time, but predominantly that's the impetus for having a guardianship.
Yeah, I think back to the years, and we go back 20, 25 years, and I can remember being called by a judge or a judge's assistant and ask specific questions about my write-up as to what did I mean when I said what I did.
Right.
And that's not an easy thing to do.
Correct.
I think that when we're forced to go into a guardianship, as you're describing, we take the personal part of it out of it, and we cause somebody else to have to make decisions. The families, if they do what you do in elder law, if they did that, they wouldn't get to this point sometimes in this guardianship business.
Correct. There's a series of documents that we usually recommend people do: a durable power of attorney, a designation of healthcare surrogate, and a living will. And the purpose of all those documents is so that you don't have to go to court to get the power to manage somebody's finances or healthcare. Sometimes we still have to go to court. As you know, dementia is usually not black or white. It's
right.
Some varying shade of gray. And depending on where somebody is on that spectrum, depends whether or not they have insight to their own condition, if they have poor executive function, which is decision-making skills, in addition to just a loss of memory. So sometimes, even though you've done those documents, the person you're acting or trying to act on their behalf won't let you. They won't listen, or they will block you or thwart your actions. So sometimes it's necessary to go to court and still have the person declared incapacitated. However, those documents are a good starting point and can prevent a lot of money being spent if you have those things in place.
I have found over the years that in my last job in the Navy, when I was the commanding officer of the Navy's retirement home in Gulfport, Mississippi, a number of wills came under contest in the court. And not one time, not once, did I ever have a judge reverse what the patient had said he wanted done in this will. Families would try to break the will, and I'm sure this kind of a thing comes up, and it's one of the reasons why we have guardianships.
Correct.
But a judge and the courts take a very, very strong view towards trying to do what a client or a person puts down in their will, or what they want their terms of their guardianship to be.
And it all depends also when those documents were done. If those documents were done 5 years ago, and then all of a sudden you have full-blown dementia, you're more likely to honor those documents than if one of your kids showed up 24 hours before the guardianship and took you to a lawyer's office or downloaded some forms off the internet and had you sign those, knowing full well that you may be suffering from some sort of infirmity.
Okay. In setting the stage for talking about a guardianship, I would say that you'd have two types: a contested guardianship and a guardianship that sort of flows through smoothly.
Correct.
How would you? Let's take the guardianship that goes through smoothly. What is the process for that type of guardianship?
Well, like I said, we filed the petition to determine incapacity. The examining committee goes out. They file their report back with the court. And then there's an attorney who represents the incapacitated person who, by law, has to go out and visit with that person.
Okay.
So they go out, visit with them. They may say, this person really needs a lot of help, and they may not contest the finding of incapacity. If that is not contested, then we go to court and we have a final hearing where the examining committee report is entered into evidence. And then what happens is we have the next step is to appoint the guardian. If there's only one petition, say one family member has filed to be guardian and they are eligible to be a guardian, then we appoint them to manage the health care and the finances of the person. Now, once they're guardian, they have to file a report every year, which includes a plan of health care for the person for the upcoming year, as well as an inventory of what the assets are as of when they took over the guardianship. And then each year they'll have to file an accounting, what came in, what went out. They may have to post a bond to protect them from the ward, which is the alleged incapacitated person, from their assets being stolen or something, because occasionally you do get bad actors. So a lot of times we'll have them post a bond. That way, if they do run off with the money, we have some other recourse to protect the ward.
And if a family follows that process, what would be a ballpark figure of what something like that would cost just to do the guardianship, not the annual monitoring, but do the guardianship? Well,
usually what you're looking at for the whole thing is about $5,000 to $8,000. Okay, and that's including paying the examining committee, the court-appointed attorney, and the attorney who is the one who files all the paperwork and goes to court representing the proposed guardian. Okay. So it's a pretty expensive proposition. That's why, doing a power of attorney, a healthcare surrogate, and a living will ahead of time is a much better proposition because it's much more cost effective.
Yep. When I do a lot of the medical type show, I talk about elements of care. Here we're talking about elements of law, and starting out with the least expensive and progressing to the most expensive.
Right.
I know that you and I have talked about, and I want our viewers to get a good understanding of why it's so important to do what you're talking about. On the other hand, now, let's say there's a contestant, and give our viewing audience an idea of what that could cost.
Well, the sky's the limit with those. You could be looking at $100,000 on some of the cases that are highly contested. It is usually pits a family member against a family member. You can contest actually guardianships in two different respects. One is you could contest the incapacity. So what you would do is, the court's got its own examining committee. You would present your own medical evidence, maybe from a psychiatrist or your own doctors, trying to say that you do have capacity. In that case, we would have a trial based on whether or not you are partially, totally, or not at all incapacitated. But more frequently, where the guardianship gets contested is at who should be guardian. So we have it determined that somebody's incapacitated. Now, who is going to be guardian? And we have two competing petitions filed to be appointed guardian, which means we can only pick one person to be the guardian, typically, especially if they don't get along. So then we have a trial to determine who's the best person to be the guardian. And you could have more than one. You could have 3 or 4 different petitions being filed, but typically it's 2. And then you have a trial to determine who's best able to become guardian. Where you typically see this disconnect or problem occur is with second marriages, where you have a new spouse and children from a prior marriage, and they don't get along, and then the parent becomes ill, and then the two sides disagree either over the health care or the financial end of things, and then they end up in court.
I know of instances, and I've had them come up, and you've talked to me about some of these types of cases where you've had a prior marriage, and the new family doesn't want to pay for the medical care, or they don't want to take care of the spouse that has now become ill, and that's where when you really have the problems.
Right, and you can have it the other way, where the kids were looking for their inheritance and they don't want all the money blown either. So you can have it blow up either way. There is a document called the Pre-Need Guardian Declaration where you can spell out ahead of time who you want to be your guardian, and that creates a presumption in favor of that person, and the court will typically follow your wishes. Most people, I don't think, realize that of people age 65 or older, 50% of them live in an extended family now. That means they've, had a spouse die and they've remarried, have kids from a prior marriage. So this scenario is very common, and that's just a product of an increased life expectancy.
Okay, you bring up an interesting point when you get into the subject of guardianships and extended families and second families. As an elder law attorney, how do you help families that enter into a second marriage prevent this type of thing from happening?
Well, you do your best. Like I said, you do those documents ahead of time, and then you tell them, have a family meeting. Get everybody in the same room. Have a plan. Let everybody know what the plan is. Too often, people just put their heads in the sand. Nobody talks about this. It's not typically a very pleasant subject to talk about. So it's easier a lot of times to go around in denial. And that only exasperates the situation, because once that family member, gets the dementia, the Alzheimer's, stroke, then it's, kind of too late to go about asking what their wishes are.
A lot of times, and it's sort of been my experience, that when the families start arguing and fighting, they forget about the rights of the patient.
Correct.
And
that's why there's that court-appointed attorney in a guardianship. They're there to protect the alleged incapacitated person through the proceedings, to make sure that their rights are honored.
Let's say if I know of a situation, and perhaps you may help me understand, and I think if I understand it, it's a point of the list of viewing audience would want to know about. I know of a case where the man had Alzheimer's. He had a lot of money. The family, thinking they were doing the right thing, established a guardianship, but they put an attorney in as the guardian.
Right.
And for some reason, the man was placed in a nursing home, and they were paying for the nursing home out of his estate, but at the same time, they had a 24-hour nurse in attendance in a nursing home. And it was eating the man's estate up, because they were spending on the order of $300,000 a year for his care, where he would have had enough money to take care of himself for a number of years. The family came to me. I happened to be at the time the director of the Alzheimer's program, and it came to me. I went to attorneys. I went to the state attorney general, and they said, Joe, there's nothing that we can do about this situation, because the judge appointed this person as the guardian, and it was something like locked in concrete. Why?
Well, you can always go back and file a petition to challenge a guardian's actions, or to have a guardian removed. So there is a recourse. You can go back through the court system and do that. But sometimes facilities, even if you have somebody in a facility, will require somebody to sit with somebody, especially if they are prone to eloping, or if they're prone to agitation and outbursts. So some facilities will require a sitter, even though they're in a totally locked down facility.
I think about this case because it was, to me, it was something that the state could have interceded in and helped, because the man ended up dying, curled up in a fetal position in a nursing home, away from his family and everything else. There was just nothing that could be done about it, but he did pass away. But it brought home to me the importance of the type of work that you do, estate planning,
and I
care
guess the
planning.
moral of that story is, do the documents ahead of time, spell out who you want to be making your medical decisions, so you don't get stuck with some total stranger doing it for you.
We go back to the Shivo case.
Right.
And there have been a number of cases since then. And even now, we don't really seem to learn a lesson.
No, only 25% of Americans have a living will. Even after that whole Terry Schiavo mess and being all over the TV, people still haven't done their documents.
They won't do them.
Well, it's denial again. I'll always have time to do it later.
And as an elder law attorney, do you often get the type of cases that we're discussing on the show today?
Yes, I get those kind of cases all the time. Yeah.
Do you find if you present things carefully and in a manner that the clients can understand, do you find that most of the time or many times or some of the times you can help them put the problems aside and work together as a family?
We try. That's always the goal. And sometimes we are able to get a third party in, especially when we have two sides of the family going at it. Sometimes we can use what we call a professional guardian. That's people who do guardianship for a living. And sometimes you put a neutral third party in there, you can placate everybody and make everybody calm down a little bit.
Okay, so once you go through the guardianship, you get the guardianship established, then you have a person that monitors that the client's estate and is responsible for making reports to the judge, as you said
Correct.
earlier in the show.
And those reports, the financial ones, get audited.
They do get audited?
Right.
So that's another thing that has to be done very carefully too.
Correct. And that's another, a safeguard in the system. Guardians also have to take typically an 8-hour course on what they can and cannot do and the accounting procedures after they're appointed.
I've heard the word guardian ad litem. Is that what you're talking about?
No, we're talking about guardians for incapacitated persons.
It's a different thing.
Correct. Guardian ad litem is typically used with dependency court, where we appoint somebody to look out for a child and oversee.
Yes, I've been asked to recommend people for that over the years.
Right.
It goes back to another show that we want to do here sometime, but it's not on the legal side, but it's on the medical side, called terminology.
Right.
Understanding what it is you're trying to fix is extremely important.
Correct.
I don't think it's any more important anywhere than in the practice of law.
And like I said, in guardianship, throughout the statutes, the term's kicked around in a lot of different statutes. And in some states, they don't even call it guardianship. They call it conservatorship, which adds to the confusion.
Call it a what?
Conservatorship.
Oh, conservatorship.
Yeah.
But I've heard that before. Conservatorship is the same thing as a guardianship?
Depends what state you're in. Sometimes it means different things in different states.
So that brings another area. And if you have a guardianship established in one state, you move to another state.
You would have to move the guardianship to the state you moved to.
So it would entail going to an attorney that's licensed to practice in that state.
Yeah, in Florida, you can move to an adjacent county without having to get permission of the court. But if you move any further than that, you have to get the court's permission. And then once you get where you're going, typically you transfer the guardianship to that county or state.
Have you had families come to you that got caught up in situations like this that did not know that they had to get permission to move?
Oh, yes. Yeah, we get that all the time. Usually it's because they had to do something for medical reasons and they had to move somebody somewhere quickly. But then we have to go back and still get the permission from the court.
Okay. As we started the show, you said guardianships were a hot topic now. Right. What has changed that would make a guardianship more of a hot item now than, say, it was 3 or 4 years ago?
Well, I think there's an explosion in the number of guardianships that are occurring. There is some disagreement, as you were talking about the fees associated with guardianships, the fees charged by professional guardians or family members, or what occurs to, because, guardianship is a very invasive procedure. We are stripping somebody's rights away, and those rights that can be delegated, we're placing with a guardian. So imagine you had to manage all the facets of somebody's life. That would be a full-time job. And so there is some disagreement about what they should be paid, how much the attorneys should be paid. And I think there's a little friction going on right now in the system. So you will see that coming probably to a head this summer with some hearings up in Tallahassee.
I know that at times you send me a section of the National Association of Elder Law Attorneys. You have a publication.
They have a newsletter, yes.
It comes in a newsletter.
Yeah.
But I have found that some of the things that I read in that newsletter are astounding. It's amazing to me that we have a system that could be extremely complicated, or it could be simplified a great deal. But it is what it is, and people can make it very simple or make it very complicated.
And for the most part, even if you have a federal program, it's up to the 50 states to interpret it how they want. And so subsequently, you get different laws in different states, and that adds to a lot of the confusion. If you do move, best to go see an attorney in the state that you move to make sure all your documents are okay and how everything works in that state.
And that's especially true in a second marriage.
Correct.
I think it's even becomes more pertinent when.
Yes.
Yeah.
I agree.
Yeah. We're just about out of time, Bill, but on the subject of guardianships, what other tidbit of information would you pass on to our viewing audience?
Well, I would tell them, go ahead, get the power of attorney, the healthcare cert, get the living will, do them ahead of time so you can avoid a guardianship. So you don't have to go through the court system and go through this very invasive procedure and get your planning done ahead of time. That way, you can be prepared if something does occur.
Yeah. And if it does occur and you don't have the documents in place, I think it's pretty safe to say that we have some pretty good laws in place that if the attorneys and the judges work together, we can generally, not always, we can generally resolve the problem where it's best for everybody.
Yeah, the system has a lot of safeguards built in there. But realize when you have a lot of safeguards, that makes a lot of hoops for people to jump through. So it's not a cheap procedure.
Okay. I want to thank you, Bill. And I want to thank you for watching today's episode of Focus on Seniors. If you have questions or comments, please call us at 321-473-7770. For more information on senior care and resources, visit our website at helpingseniorsofbrevard.com. We also ask you to listen to Focus on Seniors on radio station 1300 AM WMEL every Thursday morning at 9 a.m. and look for us in the Florida Today Health section each Thursday for our Focus on Seniors column. I'm Joe Steckler, and thank you for joining us today for Focus on Seniors. Thank you, Bill.
Thank you.
Good show. Good show.